Good morning, Mr. Mason. What do you need? You looked as if you were reaching for something.
I'm sorry, ma'am. I have tinnitus. I don't hear too well.
Okay. I thought you were reaching for something. Was there
I was
something?
going to get water.
That's fine. We can get you some water. Mr. Mason, the acoustics are such that if you cannot hear, because there's sometimes a delay, just let me know.
Thank you.
Okay.
Thank you. May it please the Court, my name is Albert R. Mason. I'm the attorney for the town of Bellingham, and I've been primarily asked to, up front, clarify a couple of things for the Court because of the problems that have come about getting here. And initially, I was asked to point out that the town of Bellingham is not arguing about or alleging anything about the goodness or the badness of a 24-hour shift. Similar to what Judge Mills said in his dissent, this is not about the good or bad of a 24-hour shift. Basically, what it is about is who should determine whether or not a shift, a 24-hour shift or a 10-hour and 14-hour shift, is the proper means, the proper way to service a community. And
hasn't the legislature said that's a subject for collective bargaining?
Pardon?
Hasn't the legislature said the hours of the shift?
Absolutely. And that's the other thing. Thank you very much. That's the second thing that I was asked to clarify. The town is not, absolutely unequivocally not saying that the 24-hour shift is not a subject for bargaining. What we're saying is similar to the case that Judge Graney was on, the Taunton case, that while it is subject to collective bargaining, there are mandatory and permissive subjects that are subject to collective bargaining. And as the city of Taunton pointed out, yes, you can bargain about it. Yes, you can talk about it. Yes, you can try and resolve it. But if you can't, there are certain inherent managerial right issues. There are certain public policy issues that should not be subject to a mandated interest arbitration procedure. And when I say mandated interest arbitration procedure, that's the third issue that I was asked to clarify from the point of view that we're not talking about voluntary, the Chapter 150E, Section 9, voluntary interest arbitration, but a mandated interest arbitration procedure. And the history of mandated interest arbitration procedures in the private sector and the public sector.
So you agree it is a proper subject for negotiations?
A proper permissive subject for collective bargaining, yes.
So it went to collective bargaining, and
yes,
then it went to arbitration.
Yes, sir. No, it didn't. We went to collective bargaining. The parties reached an impasse. In other words, we were package bargaining, and in package bargaining, we provided economics and language, and the union wanted language on the 24-hour shift. When the parties responded, they provided the economics, but did not give them the 24-hour shift. It went to the JLMC. The JLMC said, well, some of the issues that are open are the money still has to be resolved, this still has to be resolved, and the 24-hour shift still has to be resolved. They made, as the courts below have pointed out, no adjudicatory hearing on the merits of either thing, just got the list and sent us to arbitration. When we argued both at arbitration and before the JLMC that, we've bargained, and we're willing to bargain. As a matter of fact, throughout the whole process, and it'll be pointed out as well by the other side, we agreed. When the award came down, economics and everything were implemented other than the 24-hour shift. In other words, we did not try to stall or forestall the process. We said, we'll go, and whatever comes out of it, arbitrability, the question of is for the courts, not for the panel and not for the JLMC. It's for the courts. So we'll go, and if, as a matter of fact, they rule on that, we'll bring it to the courts. But everything else went into effect.
You in the next contract, you also agreed to it. Was that permissive bargaining in the next contract?
No, in the next contract, what they did was they brisk bargained economics, and they signed it, and there's a copy of it when there was a...
Doesn't it include a 24-hour shift?
They signed it saying it was subject to, the 24-hour shift was subject to the resolution of this court.
Yes.
Okay.
Are you saying that with respect to the issue of the 24-hour shifts, yeah, it's fine if we negotiate it, it's fine if we talk about it at collective bargaining, But the bottom line is, if the town does not want the 24 hours, that's the town's prerogative. Isn't that?
Yes, absolutely.
So why do you go through arbitration if it's the town's prerogative?
Well, there is a lot of case law that's saying in the negotiation process, you don't try to, and in fact it happened in the Taunton case, you don't try to forestall. You don't try to forestall or hold back or stop the negotiating process. We raise the issue. We try to be heard on the issue. We raised it to the JLMC. We raised it to the arbitration panel. We said,
but you were ordered to arbitration.
Yes, yes.
Right.
Well,
you didn't say, well, we'll just arbitrate. You were ordered to arbitration.
Well, yes. What they said is we invoke arbitration. The words they used were invoke.
The Joint Labor Management Committee invoked arbitration, ordered you to arbitrate.
Yes, sir. Yes, Your Honor.
So you didn't choose arbitration.
Oh, absolutely not. Absolutely not. No, we did not. No. In other words, as a matter of fact, the JLMC has a process where if the both parties want to go, they sign a form, just like the previous case before you where people can sign things and agree, and the town never agreed to go. But I was still trying to get to – I only got 2 points. But
you got your third, I think.
I'm trying to remember what they were.
Your third was that it wasn't mandated
thirdly, when we're talking about arbitration and mandated arbitration, I was asked to specifically emphasize, we're not talking about the grievance arbitration, the contractual arbitration that, as a matter of fact, the Taunton case spelled out is owed deference because the parties agreed, because the parties put it together. We're talking about mandated interest arbitration, statutory interest arbitration. In other words, when the issue is raised, and again, a question came up of evidence, that the evidence in an interest arbitration doesn't go to the good or bad of the 24-hour shift. It goes to what does the statute say? In other words, what does the statute say? And as a matter of fact, what does the case law say? In other words, when we're saying public policy, we're not saying, as a matter of fact, the 24-hour shift is good or bad, because we firmly believe that there are places where it may work, and because a lot of the 24-hour shift is based on the size of the department, the frequency of calls, the severity of the calls, the number of staff. There's a lot of things. So there are places where it may, primarily when you're just pure firefighting, when it's all physical, or when you've got advanced life support tied in with firefighting.
Have a lot of cities and towns gone to the 24-hour shifts?
Just
I didn't see many.
There are 351 communities. Throughout this process, I've been aware of 14 to 16.
They're all around Bellingham, aren't they?
That's all it was made aware of. Pardon?
Aren't a lot of them right around Bellingham? I mean, that's what the record seems to suggest.
If this is done, the whole working month is 8 days?
Pardon?
If this is permitted,
yes. And
doesn't that strike you as odd? That somebody can get paid for a month's work and do it in 8 days?
Not so much odd, but concerning from the point of view.
These folks precluded from taking other jobs on their
Oh, no. You're
isn't that the point of trying to get this so they can work second jobs?
They historically do.
Isn't there a dispute in the record as to whether it's 8 days or the same number of days as under the old schedule?
Well, that's one of the things Justice Marshall brought up. In other words, in the lower courts, all they were talking about were the hours weren't changed, but the days were changed, and we're also concerned about that from the point of view of fatigue and safety, but also for training. Training in a fire department is not like training that we get in school. Training in a paramilitary organization is repetitive, like in the service. We all take that gun apart, take that weapon apart regularly, day and night, through basic training every day, so that if we're in a foxhole or in the dark, we can do it. It's the same training with a fire department. The pumps, the hoses, the ladders. 4 days as opposed to 2. 2 as opposed to 1, depending on whether you're 10 or 14. In other words, you cut it right in half. And the repetition, and you expand the time away from that training. Again, goes to the safety issue. But again, we're not here to argue about the good or bad of the shift.
But you are here to argue that this is that on the facts of this kind of change or this kind of proposal, that the town's prerogatives are interfered with. Did you present any evidence to that effect as to why this?
Yes, we did. We did at the arbitration because, again, they asked, and every time that we did, we pointed out that our position still was that it was not arbitrable. We weren't going to not answer questions. We were not going to not respond. So we did point out, and primarily when we went to the fatigue issue, and at the time there was no survey available. As of September of this year, on the website for the International Association of Fire Chiefs, it's posted. There's a posted survey that points out after 18 hours awake, an individual is as impaired as blowing a .05 or 8 in an alcohol blood test. And that's on the website. But, again, that wasn't there because it couldn't have been there.
Have you ever taken advantage of the provision in this agreement that, you know, if it wasn't working out, you could go back and open the issue?
No, Your Honor, because we were here, number one. And number two, the most important reason we wouldn't do that is because that changed. That absolutely changed the criteria that was spelled out in legislation. In legislation, it spelled out interest and welfare of the public. That's number 3 item in the criteria that must be used to assess whether or not the award was proper. That's not what the arbitrator said. What the arbitrator said, you're going to go and talk about the interest of the... But the criteria that you're going to use is going to be overtime, training, and morale. And they left out the interest and welfare of the public. That's not the criteria that... In other words, they basically changed the interest arbitration criteria from interest and welfare of the public, which would have gone to safety and the training as well, to morale,
training,
sick leave and time. In other words,
you said
and also
as well.
put it... Pardon?
Training. Didn't you say training?
I'm sorry?
Didn't you say training would be an issue as well?
Yes, training would be included, yes. But the fatigue wouldn't be because, as a matter of fact, even if we raised it, they left out the safety issue that we've raised from the day one.
One of the interesting submissions by the union is that in any given 24-hour shift, there are intense times and then times when nobody is active. There's no ongoing fire, ongoing calls for emergency. Am I to draw from that these firefighters are sleeping?
No. Not to my knowledge.
I would hope not.
No, in other words, sleeping time would be negotiated time. In other words, if they were to sleep, they would negotiate. What they were saying is in frequency, and in fact, it was never, sleep time was not part of the subject, and is not. To the best of my knowledge, I don't know of any contracts that negotiated in sleep time. But what they're saying is when we're not affected by the frequency of calls, we get a time to rest, and that gives us. But again, that goes to the concern, for example, at Cape Cod, and I represent primarily small communities. At Cape Cod, they may have 222 calls in a year, 200 of them from May to September. Think how much sleep time or rest time you get, and plus, because they're smaller departments, they're combined with advanced life support services as well as firefighting. And that's what our main concern is. That's why we say not the good or bad, because some places where it's pure firefighting and they're doing pure physical, and the pure taking the gun apart or the pumps and whatnot that come by repetition, maybe not a big problem.
Does the record show, did the Bellingham Fire the Bellingham Fire Department, does it have paramedic functions?
Yes, Ron. Yes.
So within this 24-hour period, some of these firefighters would have to go out on ambulance calls?
Yes, Your Honor.
Aren't the 24-hour...
In fact, we have 2 ambulances.
Mr.
Two
Mason,
ambulances.
aren't the 24-hour periods also back-to-back now? Aren't they...
No. That was one of the things that was talked about from the point of view that they said firefighters currently work 24 hours because we had
No, I'm talking about under the new regime.
No, nobody's working back-to-back. Well, swaps happen
Correct.
oftentimes without our knowledge. And it's possible that it's not happening with knowledge. It's not happening with approval. And what I was saying is with a 10 and 14, when there was a swap, an individual would be going from a 10 to a 14 or a 14 to a 10 and would work no more than 24. If there was a swap now, They'd be going from a 24 to another 24. That.
Mr. Mason, how many firefighters are there on each shift?
I can't answer that, Your Honor.
Is it more than 10? It doesn't matter.
No, Your Honor.
It's fewer than 10.
Pardon?
It's fewer than 10.
Yes, Your Honor.
Thank you, Mr. Mason.
I didn't get them all in, but that's all right. Thank you.
The one thing I can assure you, we will read your briefs and we will read the record, Mr. Mason. Mr. Quinnen? Oh, I'm sorry. Yes, you're going second. You are. I saw you get up and I wasn't sure if you were going to go second, but you are.
May it please the Court, Assistant Attorney General Rob Quinnen for the Joint Labor Management Committee. I will be focusing on the legal construct that applies in this case and will generally defer to my brother counsel regarding any questions regarding the particular situation in Bellingham.
I know you point primarily to the language, correct? To the statute.
That's right. Yes. In fact, the JLMC is authorized by statute to order binding arbitration of disputes regarding the shift schedules of municipal firefighters, and it is not precluded by the common law from doing so. There are multiple indicia of specific legislative intent confirming the arbitrability of work schedule disputes. First, the texts of Chapter 150E and the JLMC Act confirm the issue of shift schedules is arbitrable. Had the legislature not intended for the
JLMC... It seems to me, if I can interrupt, at least there's an argument, at least it raises a question for me, Mr. Quinnen, that it's one thing if you're talking about... Here, what you're not doing is simply rearranging existing shifts, but you're moving to what is really an extraordinarily long period of time. Now, I understand there might be other fire departments that do that, but particularly where somebody is acting as a paramedical, and I think we can almost take judicial notice of the fact that there are lots and lots of studies that suggest that reaction time is simply not as prompt at the end of truly focused 24-hour care. The town raises this question, and I'd like to know how you answer it. If something, and I hope it never happens, something terrible happens on the 23rd hour, who is going to be responsible? If there is, some kinds of response to a medical emergency which is deemed not appropriate, and the evidence is that the firefighter was tired, coming off a very tough shift. There had been 3 fires earlier in the night. It had been one of those really, really tough nights.
Well, that's something that currently happens even before this award was issued.
I know, but you're stretching to 24 hours, which is very different on a regular basis. All of your firefighters, all of the time, are going to be on 24-hour shifts.
Well, that's something that's not unusual in the Commonwealth of Massachusetts or nationally. In fact...
Well, it may or may not be, but the question is that what the legislature contemplated when it was talking about hours?
Yes, I believe it is. I believe the legislature did intend that the matter of shift schedules...
This is not shift schedule. This is going beyond... how long have the 24-hour shifts been in existence?
For decades.
So your position is you have the authority to order arbitration?
Yes.
That's what you did here?
That's right. And the arbitrators who are expert in this area, at least 3 of the members of the Joint Labor Management Committee are firefighters themselves, or fire officers. And the panels reflect that expertise as well. They understand these issues very well. They look at what is prevalent in the surrounding area. They look at the overall situation for the Commonwealth of Massachusetts, and they are aware that the 24-hour shift schedule is something that has been the subject of field trials over recent decades, the past 30 years at least.
I haven't looked at the entire record, but at least Judge Mills says that that's not in the record. Is that in
the expertise of the agency, of course, is not reflected fully in the record.
But it's a little different than when you've got arbitrators. I mean, no, I understand it, but it's not in the record. So if there's a challenge, are you saying it's not in the record?
Well, the awards in 13 or 14 other cases in which the same award of 24-hour shift schedule was made is in the record. And it's in the record that 11 of the 12 surrounding communities operate on a 24-hour shift schedule.
So you would simply disagree with Judge Mills that Massachusetts appellate decisions, which clearly require more fact-based inquiry, are virtually ignored. I mean, you would say we don't even get to the facts. We simply defer to the agency's expertise.
That is a very important component here.
But it's a little odd because, generally speaking, you look at what the underlying evidence is, and then you say it wasn't arbitrary or capricious. I mean, there's some basis in the record to support the finding that, and then whatever the conclusion is.
That's
Here,
right.
that's not in this record, correct?
Well, here there is no evidence of any problems associated
But was there
with
any evidence at all about, factual evidence about how this would operate?
Well, there was evidence that that 24-hour shift schedules were in operation in all the surrounding communities, that many Bellingham firefighters worked 24-hour shifts because of overtime or the need to cover for other firefighters.
But that's not on a regular basis. They may have done it from time to time, but presumably they weren't doing it, every week.
The opinion also says the record before the panel, there was also information indicating that 24-hour shifts are common throughout the United States. Is that accurate?
Yes.
Was there evidence of that?
Yes, that is accurate. And this court has before it an amicus brief from the International Association of Firefighters stating that the majority of their 3,100 affiliates throughout the country operate on a 24-hour shift schedule. That is a fact that the court could take judicial notice of.
Did the town, I'm sorry to interrupt you, but you may not be able to answer this. Did the town offer any evidence about, factual evidence about its safety concerns, or was it permitted to?
It was certainly permitted to do that. And to
Did
my
it do
knowledge,
so?
it did not. However, I am going to defer to my brother counsel who was present at that arbitration. I wasn't.
It
So to
said,
go-
and maybe the city was, it said the city was refused to present evidence. Maybe that's incorrect.
I don't know. I wasn't there. But to get back to the legal issues here, we have confirmation in a second place, in addition to the text of 150E in the JLMC Act, the fact that the legislature designated a statute governing firefighter work schedules, the old platoon system schedule, as among those that might be overridden in the collective bargaining process.
But is that really help? Okay. How does that help you?
Well, logically, it follows that if the legislature intended that collective bargaining could be had on this subject, and that it could, in fact, override a statute, that it cannot be a core managerial prerogative.
Well, you could, but, okay, I see. But, I mean, you can certainly collectively bargain things that are beyond what is mandatory in the permissive area, right?
That's true. But
And
if-
And can't you bargain away core functions?
No.
Can you bargain them away? Voluntarily, I'm talking, just bargain away core functions?
No. No. The
Sure they
courts have
can.
said that you cannot bargain away core managerial functions. So it would not be possible. The legislature thereby gave an indication that this cannot be core managerial function. And it isn't, because it doesn't go to the fundamental operation of the function of the fire department. This award changed very little, in fact, about how firefighting operates in the city. It merely compressed different work schedules. It didn't reduce to 8 days the number of days that firefighters work. They still work 16 days per month. It just compressed the time and the timing of when different platoons work.
Thank you, Mr. Quinnan.
Thank you.
Good morning.
Good morning. Just to briefly follow up on that last point, and then I'll go into some of the factual discrepancies which my brother, I think, has improperly raised. With respect to the statute, there are only two ilks of creatures. There's those which Chapter 150E, by legislative intent, has shown to be subjects of bargaining, proper subjects of bargaining. And if those are proper subjects of bargaining, then it's clear that the legislature intended by the JLMC statute for those matters to be a subject of arbitration, unless they're one of the very few matters which are specifically excluded by the legislature in the Joint Labor Management Committee statute.
And hours of work are one of those subjects.
Hours of work are one of the most core bargaining functions in Chapter 150E, and it's clear, as my brother just said, that the legislature intended, when it enacted the Joint Labor Management statute, that hours of work and schedules be subject to arbitration because, as he said, in Chapter 150E, it specifically says that if there's a conflict between the statute setting platoon systems, the old fire department platoon systems, and a collective bargaining agreement that provides for shifts, the collective bargaining agreement shall prevail. And the JLMC statute specifically says that matters which are appropriate for bargaining under Chapter 150E are appropriate for binding arbitration unless it's one of the few matters excluded. So as a matter of legislative intent, I don't see how one, despite what your thoughts are about this 24-hour schedule, I don't see how one can come to the conclusion that the legislature intended to bar shift schedules from being arbitrated.
Is it the town's argument that it's an assignment and therefore excluded?
That may be their argument, but the 8 judges who have heard that argument have not bought it, and I don't think it makes any sense. When you see the plain language of assignment, it talks about who you assign to a particular ambulance or who you assign to a particular job because you want a specialist doing a specialized job. Assignment has a common term that you have interpreted in the MBTA case, and is far afield from what we're talking about here. It's very important to understand this does not in any way impair the ability of the town to assign whoever they want to any shift. There's no impairment of that whatsoever.
Or how many numbers of people.
Or how many numbers.
Can I ask you this?
Yes.
Is it your position that work shift structure issues such as this could never implicate sort of core management prerogatives? That's simply, or do we have to do a more fact-based inquiry about whether in this circumstance it would implicate core policy?
My position is that shift schedules could never do that. Now, you would come to a closer question if, let's say, you had a department that only had a day shift, and the union was saying, we want you to create a night shift. That would be a level of services issue, which you have found in different cases to be core management function. Here, you have to understand the limited nature of what the JLMC panel did. The shifts have not been changed at all. Prior to this award, there were, on every 8 days, there were 4 shifts worked by firefighters. It was one 10-hour day, followed by one 10-hour day, followed by one 14-hour night, followed by one 14-hour night. 16 days in a month, as someone has pointed out here. When the panel issued their award, they awarded one 10-hour day, followed by one 14-hour night, which spans 2 different days because it's 8 a.m. to 8 a.m., followed by 2 days off, followed by 8 a.m. to 6 p.m. to 6 p.m. to 8 a.m., followed by 4 days off. It's the same cycle repeating itself, 4 shifts in an 8-day cycle over a period.
Why doesn't that come out to 8 days? How do you get this? If I start at 8 a.m., because you're saying it's Monday 8 a.m. to Tuesday 8 a.m.,
right.
You're counting that as 2 days?
Right. Yes, that's 2 days. You start at 8 a.m. on one day and you don't get done to 8 a.m. on the next day. It's the same amount of days. You're working the exact same 16 shifts per month, and it's the exact same number of day shifts, 2-day shifts per 8-day cycle, 2 night shifts. It only compresses them. That's what Mr. Quinnen was trying to say. It's, of all the things you could think of regarding work schedules, it's probably the least, not the greatest, intrusiveness.
Is it, Mr. Let me ask you this. Is there any way that with this schedule it could impact the assignment? Let's say
No.
Let me finish my question,
Sure.
and you can probably answer it. Let's say, the town does a study and sees that there's just an enormous amount of activity Friday through Monday and less activity Tuesday through Thursday. And so what they want to do is shift some people over to the Friday through Monday.
It would not impair their ability to do that at all, but I must inform you that the way, and I represent 70 fire unions, the way every fire department works throughout the country that's a full-time fire department, they're all based upon platoons, and you assign a number of individuals to each platoon, right. And then you rotate the platoons over, a 24-hour, 365-day cycle. And that's always the way it's been and always the way it will be. In fact, the evidence in this record shows that west of the Mississippi, and there was evidence of this at the arbitration, every fire department literally in the country west of the Mississippi has the 24-hour schedule, and they've been operating that way for many years. Recently, over the last 20 years, it has made its way to the East Coast, and the evidence at the arbitration was a majority of communities in the Commonwealth of Massachusetts have gone to the 24-hour shift, many by agreement, some by the various 14 awards issued by the JLMC awarding the 24-hour schedule. And it is now the majority of communities that have the 24-hour schedule, and there is no evidence.
What's the advantage of it?
What?
What is the advantage of such a shift?
There are a lot of
advantages.
advantages.
Other than people can work at another job.
No, there are a lot of other advantages that actually benefit the town. For example, it's the 6 p.m. period where shifts are changing over. That's one of your busiest period, car accidents and things like that. Well, if you have a crew coming in and another crew is already out and they have no apparatus, they sit there and do nothing. If you're there for 24 hours, the chances are that you're not going to have this holdover and shift change problem. You have fewer shift changes, and that impairs the efficiency of the department.
Don't you have that at 8 o'clock in the morning, which is also when there are lots of car accidents?
Well, but you have that anyway under the old schedule. You have fewer, you have half the shift changes.
I see. You
don't
have it at 6 p.m. and 8 a.m.
Right. In addition to that, there's evidence, if I may, that sick leave and injury leave is cut down considerably because if the firefighter comes in at 8 a.m., they're there for the whole day. It's less likely that someone will call out sick for whatever reason, be injured, and there's overwhelming evidence in the record to support that proposition.
Is there any evidence in the record that the town offered evidence about its safety concerns relating to this schedule?
Let me address that. For, I think, correct reasons, there is not a requirement in the JLMC statute, or the JLMC has never imposed a requirement of there being an administrative record. And I think that's because of the flexibility given to the JLMC to decide these issues in the way most efficient for all parties. However, at the hearing in this matter, the town presented one witness, I believe it was the chief, who mentioned some safety concerns. We presented overwhelming evidence that it had been working beautifully in the 11 communities surrounding Bellingham without any problem whatsoever, that has been operating around the country extremely well without any problems, and the panel correctly decided that there was no evidence in the record before from which one could decide that there was any safety concern posed by this so-called fatigue factor, which I submit to you is a complete red herring for this reason. Currently, all firefighters, whether they work a 24-hour shift or they work day and night shift, there is downtime during the night shift. There has always been downtime during the night shift. Someone said, well, firefighters sleep. Yes, there are beds in the firehouse. Firefighters rest during downtime at night. It's always been the case. That's not surprising.
Can I just interrupt?
Yes.
I take it, and the reason why I asked you about the impact on assignments, I take it, therefore, that if you have the dissent's opinion in front of you, it's on page 529, you would simply disagree with the dissenting justices from the appeals court conclusion that when you consolidate, to 20, they use the term consolidate,
yes.
And I understand you're not saying so, then the ability of the executive, that's the town, to make discerning and informed assignments with reasonable flexibility may be substantially impaired.
Yes.
You were saying that if we drill through the record, we will find that the assignments are not substantially, or not, as I understand it, not impaired at all?
Not changed one iota. The chief still has the flexibility to decide who he wants on which platoon, how many people to have on the platoon, who to assign to what. There's absolutely no impairment of the flexibility of the chief to make assignments in a way that he thinks best carries out the department. It's not an issue in this case. I believe in Bellingham, the chief has absolute discretion as to who to assign to which platoon, how many people to have on which platoon, who the officers should be.
And is that in the record?
Yes, that's in the record. It's been extensively
briefed.
briefed.
So just to make clear, so that the next sentence, the determination whether the scheduling change, i.e. the work hours, interferes with the conscientious assignment of individual workers to shifts and teams and thereby invades management prerogative, for example, requires more analysis. You're saying it doesn't implicate that at
Yes,
all?
with all due respect to Judge Mills, he's just wrong on that.
Okay. Does this 24-hour shift essentially eliminate the effects of seniority in the sense that everybody is working a shift that begins at 8 o'clock in the morning and goes to 8 o'clock the next morning, and everybody effectively will work the same number of Saturdays and Sundays?
Yes. In fact, it's always been that way in the fire department. In fact, while this isn't before you, under the rubric of work schedules, if a fire union came in and said, well, once we get senior, we only want to work days and we don't want to work weekends anymore, that would be a more interesting issue. I'm not saying that it was
You're not
something.
going to concede that.
What?
Representing 75 departments, you're not going to concede that.
That's correct. But what I'm saying is this has none of that potential intrusiveness whatsoever. This is a simple case. It does very little to change the way the firefighters structure their work.
Thank you, Mr.
Thank you very much.